Wait, please, Your Lordship. Alright, need to mention for listing of a writ petition, my lord. What happened, my lord? On 2nd of February, my lord, letter of acceptance was issued, my lord. After on 20th of month, my lord, February, my lord, the chief engineer has directed the executive engineer to call a fresh tender, my lord.
Tomorrow?
Tomorrow, my lord.
My lord,
Okay.
item number 8 and 9, my lord. These are
Item
IUCL.
9.
8 and 9, my lord. These matters are tagged, my lord.
Hmm.
I appear on behalf of the IUCL.
Yes.
This is the second time the matter has been listed, my lord. We'll be filing our affidavit during the course of the day, my lord.
Hmm.
And my
8 and
friend
9.
is also here for the petitioners.
Well, it's may kindly this time for rejoinder.
8 and items from?
8 and 9, my lord.
The status quo.
Teresko, my lord. That the allocation should not
Okay.
happen if not already.
Sir, you were?
C. Garg.
C?
Garg.
Garg. And counsel for the petitioners. Then Mr. M. Sharma,
My lord.
and counsel for the respondent,
IUCL.
IOC of India, has submitted that a counter affidavit on behalf of IOC of is going to be filed
Today, my
during
lord.
the course of the day.
Today, my lord.
Because with a copy, the land council copy. Yes, Mr. Garg, you want?
Well, it's 2 weeks for rejoinder.
Mr. Garg has submitted a counter affidavit file today. He need time, file, and affidavit in reply. Right? Yes, that's wait for listing of the case subject to case. The case on so and so date.
2503.
My lord, I'm grateful.
Yes, I'll continue. till
My
the
lord.
next day.
My lord.
Obliged.
Same in 9?
8 and 9 are same, my lord.
Same 9.
Same, my lord.
Obliged.
May I please, Your Lordship? Lordship, I am paying for listing of two motion matters tomorrow, Lordship. One is on my behalf and other is on behalf of my colleague, Miss.
Yes,
Miss
what is the urgency?
Lordship, we have challenged one NIT issued by the Numoligo refinery, Lordship. During the pendency of the first case, Lordship, they have now changed the price bid, Lordship.
Okay.
Obliged.
Lordship. Okay, I'm paying for listing the matter, Lordship, the unlisted matter, Lordship.
Why? What is the urgency?
Lordship, agency is Lordship, the NIT has been issued. There is a condition that pre-visit certificate is required. Lordship have adjudicated the matter yesterday, Lordship. Lordship allowed 3 petitions. After that, Lordship, we think that all the petitions will be allowed. But Lordship, they have said that now who has come with the court order, they will be allowed. And Lordship, it will be difficult, Lordship.
Okay.
Obliged.
May I please, Your Lordship, I beg to mention an item for listing day after tomorrow. It's a contempt case. It last came on 7th.
Order. Give it
Order.
to the court master.
Lordship.
May please, Your Lordship. I beg to mention for listing in the admission column. This old matter,
What is the subject matter?
non-payment of contractual.
Give it to the court master.
May I
Please give
please,
it to the court master.
may I please, Your Lordship, I beg to mention for listing of 2024 matter. It was last listed on July for admission, Lordship, kindly.
Madam, please give it to the court master.
May it please, Your Lordship. I beg to mention a writ petition for urgent listing, Your Lordship. The matter is pertaining to an order.
Motion matter.
Yes, Your
Ah.
The matter pertains to an order passed under section 74 of the CGST Act. Our challenge is that it is without jurisdiction.
File.
Okay.
May it please, Your Lordship. With the consent of the petitioner, I beg to mention item number 4. Here, my lord, P. Nayak additional AG has some difficulty to the 4, my lord.
Who has difficulty?
My lord?
Not.
Oh, no, my lord, P. Nayak. Padma Nayak, my lord.
He is for a state.
Yes, my lord.
Okay.
4.
Please, Your Honor. I'm in 4.
I'm
for the petitioners in 4. So I believe Nayak wants a short accommodation. So any date after if 17th of March is protocol because there's a urgency. to
Does
the fact.
Mr. Learned Counsel for the petitioner is present. The G. Bokolial Learned Junior Government Advocate, some appearing for appearing on behalf of Mr. P. Nayak Learned Advocate Assam has submitted that Mr. Nayak has some difficulty to address the court to pay and has thus paid for listing on the case after 2 weeks.
Your Honor, can you
As
fix a
sought
date
for
in
and
this
agreed
matter?
to by the Learned Counsel for the parties, list the case on. Thank you.
Obliged. Daily list for admission, item 1.
Please, Your Lordship.
Yes.
For an adjournment in the matter, and adjournment slip was filed yesterday, Your Lordship. Similar issue is pending before the division bench, Your Lordship,
I
whereby,
think there is no reason for
Yes, Your
keeping the repetition pending otherwise.
Your Lordship, the
Absolutely.
order passed under 26(1) has been put to challenge, Your Lordship. The issues are similar.
There's a
No, but otherwise, as per
Facts are different.
Supreme Court judgment, something pending before the larger bench
Yes.
is no reason for keeping the repetition pending.
And in that, Your Honor, there's a finding that
This time, you think it over. That just because it is pending before the division bench
Lordship,
may not be a ground for the single bench to
Pick up the-
defer the matter.
Lordship may kind of fix a date for another date, Your Lord. Short accommodation.
When do you want? But keep that angle,
Yes, Your Lordship, I will.
because pendency of the repetition before a larger bench
Your Lordship, I understand.
may not be a reason for a single
Simply-
judge.
Your Lordship,
That has been law,
read down.
and that has been laid down.
deeply obliged. 17th of March, Your Honor, may consider.
Give us 7. Okay, Mr. PK,
N. Datta.
and then Dr. Learned Counsel for the petition has been. I go to Likhidim. Mr. And then Dr. Learned Counsel for the petition has made a prayer for it. We make him know the effect has all very ready. Post of Mr. Piras, Learned Counsel for the phone number 2 and 3. And Mr. B. Chaudhary, Learned Counsel for present. The prayer made for adjournment out as agreed to and sought for an Learned Counsel for the parties, the case on 17.3.
Your Honor, I just got communication from the learned HGI's office that may 12th be considered.
12, any case already.
After
Any day after. Further matter, sir. Any PK goes.
Not in.
Uh,
Your Honor, it may be the 7th. I think they can, 17th, they can start.
17th.
17.
Then we'll fix a date for arrangement. Yeah. Obliged, Your Honor.
Item 2.
Lordship, may I please, Your Lordship?
Yes.
Your Lordship, this matter, it pertains to then fair price shop, which has been running at Mokra, Bhodgaon, Kokrajhar by the petitioner since
Okay, take me to the documents.
Yes, Your Lordship. So he has been running this FP fair price shop since 26 years. An FIR was issued on 13/2/2018, which is
Let us go through the documents. Let
Okay,
us go through your annexers.
yes, Your Lordship.
Ah.
Your Lordship, his FCS license was cancelled on 22nd February 2018.
Madam, take me to the
Yes,
documents.
yes, Your Lordship, I'm going.
One by one.
Yes, Your Lordship. The FIR, it's in page 30.
Right from annexer 1 so that I can
Okay.
have a
Here.
grip on the facts.
Your Lordship, Annexure 1 is the license that was issued to him,
Okay.
which is
1
in
minute.
page 26 is the type copy
Full fill
of
and
the
lines.
27.
Yes, license.
This license, your lordship,
That has been renewed
uh,
lastly up to
31st March 2019.
2019. Okay. Then what happened?
Then your lordship,
FIR.
an FIR was filed.
Let us read the FIR. Content is not there.
It's there in your lordship, page number 34.
34.
Yes, your lordship.
Uh,
This is the format. It's a format.
That was on which date?
It's on
13 to
on 13 February 2018.
Yes.
Your lordship, annexure 3, it's in page 35, which is the his license was suspended, and according to this order that is there 22nd February 2018,
Is there any specific suspension order?
no, your lordship, suspension order was not furnished to us, your lordship.
Okay.
According to this order, his the population under his shop, fair price shop, it was tagged to a nearest agent named Motiur Rahman of village Phatipara, your lordship. So your lordship, then he filed a reply.
No, madam. Next page.
Yes, your lordship. Annexure 4, which is page 36, is the show cause notice that was issued to us on 23rd April 2018.
Okay, then you submitted your reply.
Yes, your lordship, which was received.
Let us see your reply. Okay, then.
Your lordship, annexure 6, page 38 is the order which was given to us by Joint Director of FCS and Consumer Affairs, Kokrachar, where the suspension order was revoked and the licensee, he was a warning was given to him, which was recorded in his license, your lordship.
Yes.
Annexure 7, which is in page 39, your lordship, whereby your lordship an order was issued to the petitioner that his the population under his FPS. So it will be the respondent number 5, that is the secretary of MS Bhodgaon, they will be allowed to distribute the allotted quota that was there under the FPS of the petitioner, your lord, till a final disposal of his case.
Now this judgment has been annexed for what purpose? Now, what is the case of the respondents?
Lordship, because of the malpractices done by this Alkas Ali, one inquiry has been committed and one FIR that has been annexed by the petitioner himself. And one FIR has been filed against him. And on that basis, your lordship, inquiry has been committed and on the basis of that FIR and complaints, his license has been suspended, lordship. And what is the stage of that FIR, lordship? That is not before this court, lordship. And FIR contents is also not there. Only the format is annexed.
No, I can understand this one. You read this one page.
Para 12.
Page.
Yes, lordship.
You
Page
read
34.
Page 34.
34.
You read
Para 12.
clause 12.
Clause
Para
12. On 12.
That is all.
Yes. And lordship, our affidavit we have filed stating all these things, lordship. Kindly peruse our affidavit.
What is the status of the
Your
case?
lordship, the FIR is, your lordship, he has been convicted in the CGM court of,
Convicted.
yes, your lordship. But then the matter has not attained finality. He has preferred a appeal before the session judge, your lordship. And he's on bail right now.
Oh, he has been convicted. Where is the judgment?
Your lordship, that's what we have received the instruction till now.
Ah,
Judgment we have not
you
received.
must have the copy of the judgment.
Your lordship, like we have not
If
received it.
the conviction is related to his FPS license, then at this stage nothing because conviction is related to his license, right?
Yes, your-
Regarding kerosene,
yes.
right?
Under EC Act.
Under EC Act. If that is so, then he incurs a disqualification to continue with the license if the appellate court allows the appeal and he is acquitted of the charge, then you may have a different case. But as on that, if he is convicted, so you place the judgment
Yes, your
day
lordship.
after tomorrow.
Okay. We have not received.
Get the scan copy, right?
Yes, sir.
And the present status of the appeal number.
Yes, your
How about the other one? Appeal status.
Do you have the number?
Take part of the- And latest status of the appeal.
Your lordship, we just received the instruction.
Otherwise, earlier your license was suspended, thereafter revoked, right? So there is no question of tagging the beneficiaries with another fair price license owner. But as an FIR was lost, that has been succeeded, thereafter you are convicted. And that issue is not related to any other thing but the license only. So if conviction is accorded, It is fair, take an action. You get the order, dispose it of, because your license is in suspension. Or impliedly, implicitly under suspension. Heard, Miss?
K. Bhattacharya, Your Lordship.
Learned counsel for the petitioner. Mr. D. Okolial, learned junior advocate. Affirm for the respondent of 1, 3, and 6. Miss Ann Choruri, learned standing counsel. 1, 3,
Page number
6, right? Ann Choruri, standing counsel, PTC. For the respondent were 2 and 4.
2 and 4.
And what about 5?
Right. Inspector of Police. No, Bodgaon Samabhai something.
No, see.
No, no, I put.
As per order dated 30/08/2022 of the Lojima Court. Notice has been duly served. The service of notice upon the respondent number 5 is complete. So none has appeared for the respondent number 5. Is authorized during the course of submission, submit that the petitioner has been convicted under Section 7 Essential Commodities Act 1955 in the trial arising out of Kokrajhar Police Station case number 59/2018. First off, as per the allegation made in the FIR lodged in connection Kokrajhar Police Station case number 59/2018, comma, on ten to 2018, the petitioner comma and a fair price shop licensee comma had illegally sold kerosene, about 10 liters of kerosene from his shop. So Ms. Aforesaid has got for time till day after tomorrow, Thursday, to obtain a copy of the judgment passed by the trial court. This Prohibitions.
Bless.
Public
May it please your lordship. On the last occasion, your lordship requested that list of dates be provided. Yes. Because the dates were a bit confusing. Yes, for dates for one of this.
What is the
Hey,
last position?
Lordship,
What is the last position? Your
it has been suspended, your
license has
lordship,
been
by the,
suspended.
that's it. It's-
When it was suspended?
That was, your lordship, by the order dated 22nd April 2024.
25th.
22nd April.
Huh?
Oh, sorry, it is dated 22nd April, but signed on 25th. 25 April 2020.
Which page?
Page is their affidavit 72, you know. That is the issue.
25th April.
Yes, 25th April it was signed.
A reference.
The reference is 22nd, sorry, it is 25th.
Yes.
Assistant.
Yes, madam.
Lordship.
The appeal provision in the
No,
APDCL.
it is a matter of suspension.
Suspension.
Right, Mr. Bokolia. And it was on 29th April 2024. Right. And suspension period can last up to
90.
if no so-called notice or
So-called,
proceeding is initiated within a period of 90 days. Sorry, settle.
BTC, it is a.
Transfer subject, this is also clause 15(1) of the Assam Public Distribution
yes.
Articles Order. So they are following it.
is to
If
suspend.
they are living by this order, then they are also going to be dead by this order.
Lordship, as per inquiry report, various inquiry has been committed against this person.
Question is, how long it will sustain? I have
One
seen
inquiry has been completed.
at
as
your
per this-
pleasure, you have been making enquiries. Right, left and right. After getting confused, I have also prepared my list of this. Is it sustainable now?
Lordship, can it be fixed after 1 week for getting
No, no.
fresh
It
instruction?
has been
Lordship?
fixed already. It has been fixed.
It practically heard the matter that day.
No, that day I got confused.
There is,
Yes, because of the
I got confused
dates were,
by your pleading and by their pleading.
I have given certain dates in the seriatim, but what they did not give it in seriatim. That was a bit confusing.
So,
Lordship, kindly sometime,
no time.
1 week time, Lordship, because on the last occasion also I have,
You
page
file,
for-
you file, Miss
Affidavit.
Koduri,
yes,
you file this affidavit in opposition. Let us see. 20th January 2025. Right?
yes, Lord.
Is it not?
Yes, Lordship.
And see the last page of your affidavit. Last page of your affidavit, the order. April 2024?
Yes, 25th April
2024.
Yes,
So April, then May, June, July, August, September, October, November, December. 8 months. 8 months.
yes, Lord.
Is it not?
Yes,
You filed it in January. So 3 months already over by that time. You are silent as regards drawal of proceeding within 3 months. Meaning thereby nothing survives. The suspension order will not survive. But you can still proceed with the inquiry if you issue a show cause.
That may be recorded, Lordship. That may be
Why
recorded.
will record?
That is up to them.
Up
They
to
can
you.
always do it.
You are a statutory authority. This. Mr. Manan, we are not going to quash any inquiry report. Inquiry report, that is a fact-finding thing which.
It is obviously your lordship. Only thing is that
Your
the
pair
violation of
includes-
15.
No, your pair includes quashing of inquiry.
That is
Lordship, if this has been cancelled or inquiry has been committed, initiated, that's what Lordship sometime.
We don't know suspension order, we are only a suspension order.
from the inquiry. Very court will continue, allow.
Inquiry, if you have started, it can proceed.
No,
And
they
you
have
can-
already had 3 inquiries.
No.
Those inquiries remain. 2 inquiries, I think, 2 inquiries.
Yes,
Inquiry or whatever they
the
have.
present writ petition.
Mhm.
Under Article 26 of the Constitution of India is preferred by the writ petition against prolonged suspension of his license as a sub-wholesaler stroke retailer under the Assam Public Distribution of Articles Order 1980. Green bracket, and put type order. Was the case presented by the petition. And emerges from the materials on record. He is coming in brief that the petitioner was appointed. Petition was granted a sub-wholesaler stroke retailer license by on 4/3/2013 under the provisions of the APDA Order 19. The sub-wholesaler stroke retailer license, also interchangeable mentioned as PDS license, was renewed from time to time. And it was last renewed up to 31/3/2024. Para. Please take your seats. Who is for S1 number 4?
Or have also filed
On-
their affidavit.
On 30/3/2026. Comma, a public complaint was lodged by the respondent number 4 and others, comma, residents of village number 3, Siddhinathpur, under Pu Kumari Kata PSS Limited, before the additional deputy commissioner, comma, Tamulpur subdivision, making complaints about irregularities allegedly committed by the petitioner as a fair price of FPS license on receipt of the complaint, comma, the additional deputy commissioner Tamulpur subdivision forwarded the complaint to the assistant director, comma, in charge, comma, food, comma, civil supplies and consumer affairs, Tamulpur, on 5/4/2003. To conduct an inquiry and to submit a report within 10/4/2023 by the concerned area inspector, and thereafter to take needful action accordingly, necessary action accordingly. The area inspector made an inquiry on 6/4/2023 and thereafter submitted a report on 10/4/2023. In the report, the area inspector reported that the beneficiaries made a demand to collect the PDS commodities from the nearest fair price shop dealer, Bhim Bahadur Chetri, in place of the petitioner. Full stop. As there was another allegation that the petitioner was a government employee, the area inspector caused an inquiry the said issue and reported that the petitioner was not a government employee. So the petitioner he applied for a post. However, based on the report of the area inspector, the the petitioner was served with a show cause notice dated 5/8/2023 by the Assistant Director, Food, Civil Supplies and Consumer Affairs, Kamul to be here. In bracket. Or as per number 3. Asking the petitioner to show cause as to why the FPS retailer license, petitioner's FPS retailer license not be cancelled under the provision of clause 15 within bracket 2 of the APD order. In the show cause notice, it was mentioned that as per the report of the investigating officer, the petitioner had failed to comply with the terms and conditions of the APDA order. So the petitioner was asked to submit a reply in a period of 5 days, the date of receipt of the show cause notice. On receipt of the show cause notice, the petitioner submitted her show cause, reply to the show cause notice on 11/8/2020. Denying that there was any irregularity in distribution of PDS items. So the petitioner asserted that she had been maintaining all records after distribution of the PDS items. And in support of such claim, annexed all the records of distribution of PDS items along with the show cause reply. Oh, show cause. After submission of the report by the area inspector, the response number 3 passed an order on 10/4/2023. Whereby The beneficiaries under enlisted with the petitioner's FPS fair price shop were tagged with the nearest fair price shop of Sri Bhim Bahadur Setri of the same village as a temporary measure, in the interest of uninterrupted supply of the PDS articles to the consumers until further order. Full stop. Though no specific order suspending the license of the petitioner was passed, the response number 3 in the show cause notice dated 7/8/2023 had mentioned that the petitioner's license already stood suspended. After submission of the reply to the show cause notice on 11/8/2023, the matter rested in such position till 10/7/2023. On till 10/7, and there was no order as regards. There was no order either in the matter of suspension or revocation of suspension or cancellation of the license, right? Full stop. On 10/7/2023, comma, seven. Is 80/80. On till 31/5/2020. Full stop. On 31/5/2023, an order was passed by the respondent number 3. Please, Mr. Manan, page 64 is not connected with you.
Page 64.
Why they have annexed, we don't know. They have mixed up everything. Yes.
Here your lordship, somebody Seneki Daimari was allowed to give. Yes. Get the idea.
Taniki Doimari, who is he?
I don't know. And the date also, your lordship, 18 June 22, 23 March 23 are,
All these are
these are not
not
connected.
related to you. Okay, then till 10/7/2023, correct? 31/5, no, 10/7/2023. On 10/7/2023, comma.
Lordship, in our affidavit, page 50, this annexure has been stated. After he and suggested to cancel the license of Sampadas, thereafter Srimati Taneki Doimari is authorized to lift and distribute the PDS items.
Huh? Page?
Page
Page
50,
50, para 6.
Page. Keep. What is page 50?
But this, there is a problem here. Though it has been stated, kindly see,
No, I am not getting your, all these are,
they are saying it is,
though it is 100 page, but each page scattered everywhere.
what they are trying to say that it is on the basis of a report on 10/7/23.
I am coming to 10/7, sir.
But how can they pass an order in 31/5/23 on the report which has been subsequently submitted? That is why it is
That
not
is why I
connected.
have left it.
That is why it is not
No,
connected.
no, I have left it.
Yes,
After looking at it,
not connected. He's trying to say it's connected, but it cannot be.
not trying to, it is in the affidavit.
madam, the manner in which you have drafted the affidavit
Lordship, in the list
leaves
also, there are-
much to be desired.
Lordship,
Don't
in the list,
make submission now. I have
here to apni likhi. Sani-
on 10/7/2023.
Report kit here. Order kit. Can an no.
One Kosik Pathak, Inspector, Food, Civil Supplies and Consumer Affairs, Tamil, submitted a report to the respond number 3, stating inter alia that during verification, on verification of the records, it was found that the issue register was not maintained by the petitioner properly. Full stop. When he verified the E-POS transaction, it was noticed that the petitioner did not issue the PMPKAY rice properly to the beneficiaries. And thereby, had committed violation of the terms and conditions of the APDA order and the targeted public distribution control order. So it was suggested that the FPS license of the petitioner should be cancelled and a new fair price shop dealer be appointed. By transferring the license of the petitioner subsequently another complaint as regards irregularities in the functioning of the fair price law shop of the petition was received and on 8/12/2023, the respondent number 3, the additional deputy commissioner supply, Tamulpur, ordered an inquiry through an assistant commissioner and executive magistrate Tamul. As per the order of the, as per the said order, 1, assistant commissioner come executive magistrate Tamulpur conducted an inquiry and submitted a report, an inquiry report on 21/3/2024. It was in the report, it was reported that the petitioner exhibited lack of proper record keeping regarding price distribution, and the register and the concerned register was incomplete, lacking crucial information such as the quantity of rice distributed, stuff. There were other irregularities reported. It was recommended even having reported the irregularities, it was recommended that the petitioner should be precluded from further involvement in rice distribution. And it was proposed that the existing arrangements with the nearest fair price of licensee, Sri Bhim Setri should be continued. Full stop. The earlier instance of issuance of the show cause notice on 7/8/2023 was mentioned in the inquiry report dated 21/3/2020. Whereof on receipt of the inquiry report dated 21/3/2020, the council head of department, food, public distribution, consumer affairs, BC Kokaja, wrote to the respondent number 3 in reference to the inquiry report dated 21/3/2024 of the Assistant Commissioner Executive Magistrate Amulpur, reporting irregularities committed by the petitioner in distribution of NFSA rice as both regular and PMGKAY The respondent number 3 was requested to initiate legal action against the petitioner under the provisions of the APDA Order 1982 as the respondent number 3 deemed fit and proper. Both on 22nd April 2020. Subsequent to the request made in the letter dated 22/4/2024, the impugn order dated 25/4/2024 came to be passed by the respondent number 3. Full stop. The impugn order has been passed in reference to the office letter dated 22/4/2024 of the Council Head of Department Food, Public Distribution Consumer Affairs BTC. Full stop. By making such reference, comma, the response number 3 has suspended the fair price of license, sub-wholesaler stroke retailer license of the petitioner with effect from 25/4/2024 in exercise of the powers conferred by Section 3 of the Essential Commodities Act 1995, comma, the Targeted Public Distribution System Control Order 2021. Now, targeted Public Distribution System Control. And clause 15, in bracket 1 of the APD order 1980. Full stop. Where I have heard Mr. Y.S. Manal, counsel for the petition, the Z. Bokotiel, and Junior Government, Assam for the for one and Miss Ann Chaudhary, and training counsel for the respondent number 3. None has appeared for the respondent number 4. Okay. On okay. Despite service of full stop. Now, targeted training. Very yes. targeted order, have you checked the provisions? That one, it is not only that the order has been made under targeted public distribution system control order. 2021. 2021. Huh? 2021. So far APDA is concerned, APDA order is concerned, it is clear. 3 months, but
15.
without
Yes.
checking this one, I cannot pass an order. Suspension cancellation provision is also there, 2015. I have 2015, but they have referred to 2021.
Trying to find the.
But there, 2020, 2015, the provision is slightly different. The Manal and Constable Appeal submitted that as per clause 15(1) and clause 15. The AP, comma, if suspension can, if an order of suspension is passed, then the consequence occurs notice. Or then
From their website, the website, the government.
in contemplation of any proceeding for cancellation of license, then such proceeding is to be initiated within a period of 90 days.
Right.
And in the event of failure, the order of suspension could not survive. On the other hand, so understanding has submitted that the petitioner's reports from the various, it is evidently clear that there were many irregularities committed by the petitioner while operating the fair price shop on the basis of the license granted under the APD order. And as such, no interference is called for.
There is.
Madam, have you quoted wrong thing or what?
There is no 20.
Huh?
There is no, I have gone to department website here. There is 15, then 2025, no 2020.
15 and 2025.
Yes. He has also seen there is not available. I have gone to their website, Government of India, their department website.
2021 is not there.
No.
We have to.
This 2015 is there, your lord.
2015 I have got.
Then your lordship, targeted public distribution system control amendment order is there in 2025.
Para. section clause
No, no. One.
clause 15 of the APD has provided for suspension and cancellation of license or sub-wholesaler stroke retailer license granted under the APD order for ready reference. Clause 15. Okay. Para. Clause 15(1) of the APD order has envisages that cancellation or suspension is one of the actions that may be taken without prejudice to any other action that can be taken under the Essential Commodity Act 1950. Clause 15(1) has indicated the course of action that are available under the APT order in the event of contravention of terms and conditions of the license by a license. Para. Section clause 15 (2) has provided that no order of cancellation shall be made unless the license has been given a reasonable opportunity of stating his stroke her case against the proposed cancellation. However, during the pendency or in contemplation of the process of cancellation of the license, the license can be suspended for a period not exceeding 90 days without giving opportunity the license of stating his stroke her case. Para. From the aforestated provision, is emerges that when a cancellation process is pending, even if suspension was not resorted prior to initiation of the cancel proceeding, then also it is permissible to suspend a license. Is a perusal of the provision has made it clear that a license cannot be suspended beyond a period of 90 days without affording the licensee of stating his or her case. Full stop. In other words, a license cannot be kept suspended beyond a period of 90 days, unless a notice is requiring the licensee to cause as to why his stroke her license shall not be cancelled. If during the period of 90 days, no show cause notice is issued, initiating a proceeding for cancellation, requiring the licensee to state his stroke her case, the suspension order would automatically spend its force. Full stop. Para in so and so. As of.
Can we say for this 20?
As observed as a. Para. Despite Mr. Manan, the learned counsel for a petition has submitted that despite his efforts, he could not lay his hand on any order named as a targeted public distribution system control order 2000. He has submitted that there is the targeted public distribution system within bracket control order, 2015, framed in exercise of and subsequent amendments in 2025.
Two amendments, one in 24, one is with regard to one nation, one ration card. The other was
24
something,
attorney given.
24 and 25. There are two.
Amendments in 2000. Ms. Chaudhary understanding has also submitted that he's also unable to get any. We have to lay our hands on any control order by the name of targeted public. Second, 2000. Para when the targeted in the absence of the targeted public distribution system within bracket control order 2021. This court has looked into the provisions of the targeted public distribution system within bracket control order 2015, framed in exercise of powers conferred by section 3 of the Essential Commodities 1995 and in supersession of the public distribution system within bracket order 2001. So the order has been framed for maintaining supplies and securing availability and distribution of essential commodity, namely frames under the targeted public distribution system. As per clause within bracket small I, quote unquote, designated authority means any officer not below the rank of Food and Civil Supplies Inspector in the state government. Full stop. As per clause 2A, comma, quote unquote, fair price shop means para clause 9 of the order control order with the was what provided for license fair price shop. And clause 10 as prescribed for the operation of fair price shop. Oh, okay, take note. As per subclause 7 of clause 10, comma, the designated authority shall take prompt action in respect of violation condition of license, including any irregularity committed by the fair price shop owner, comma, which may include suspension or cancellation of the fair price shop owner's license. Full stop. Subclause 8 therein has laid down to the effect that the state government shall prescribe a maximum period within which proceedings relating to inquiry into irregularities committed by the fair price shop owners shall be concluded, comma, resulting in any action as under subclause within brackets 7. Full stop. By subclause 9 of clause 10, final as envisages for alternative arrangement by providing that case of suspension or cancellation of the license, comma, the state government shall make alternative arrangements for ensuring uninterrupted supply of food grains to the eligible household. Para, on a combined reading of the aforesaid provision of the Control Order 2010, comma, it is evident that it is only after conclusion of an inquiry the action comma, either suspension or cancellation of the fair price shop owner's license can be taken by the designated authority. So in other words, comma, the action and the neither cancellation nor suspension nor neither suspension nor cancellation of the license can be taken by the designated authority prior to conclusion of the inquiry. Para. When having regard to when in regard to the aforesaid provision of the APDA order and the control order, comma, it is evidently clear that if after an order of suspension, no proceeding is initiated for cancellation of license, then such an order of suspension not survive beyond a period of 90 days, the date of issuance from the date of issuance. So, in such view, the matter, the order of suspension. Full stop. In the affidavit of opposition on behalf of the respondent three was filed on 20/01/2025. That is after more than 8 or 9 months. 8 or 9 months.
It should be
April.
8 months. 8 months, some few days.
More than 8 months from the order dated, order of suspension dated 25/4/2024 and
8.5
more than 8 months.
Yes.
And it has maintained silence about initiation of any proceeding within a period of 90 days from 25/4/2024. Para. In the above, in the above obtaining fact situation, the suspension of license ordered on 25/4/2024 by the respondent number 3 has spent its force under clause 15 in bracket 2 of the APDA order. Full stop. And therefore, it is observed that the order of suspension stated so and so is no longer in para. The fact of non-survival of the suspension order would not, however, preclude the respondent authority to proceed in any manner to proceed for cancellation of the license of the FPS fair price shop sub-wholesaler stroke retailer license of the petitioner, if they wish to proceed further in view of the allegations made against the petition, against the petitioner license, against the petition as a license. So, but before any such action is undertaken, if such proceeding is undertaken, but any such proceeding undertaken shall be strictly in accordance with law, and a reasonable opportunity must be provided to the petitioner by way of a show cause notice and furnishing inquiry reports, if any, and to allow an effective thereby and thereby allowing an effective opportunity, thereby allowing the licensee to submit an effective reply to the show cause notice. System. In view of the order passed, observation made in with regard to the suspension order dated 25/4/2004, the license, the fair price shop sub-wholesaler stroke retailer license of the petition as stands deprived, and the respondent authorities shall accordingly take necessary steps for allowing the petition to function, to operate, to run the shops, to run the fair price shop in accordance with law. So, the petition is allowed, stands allowed to the extent indicated with observation direction. The petition is allowed to the extent indicated. There shall, however, be no. So we proceed with the inquiry.
May please, your lordship. My lord, this writ petition has been filed, my lord, praying for a waiver of the, my lord, the case for the delayed period of handing over of the, my lord, of the fishery. My lord, fishery was handed over 213 days, my lord, belatedly. For that period, my lord, the petitioner is asking for that, my lord, the waiver. And also, my lord, the ecological system of the fishery has, my lord, gone to such an extent that it is not, my lord, now functional almost. So, my lord, on his prayer, the Deputy Commissioner directed, my lord, the inquiry to be made, and there are two reports, one by the Fishery Development Officer, another by the Circle Officer. They are finding that, my lord, the fishery has become encroached and, my lord, filled with synth and all, and the cleaning is required. So in spite of that, my lord, the authorities have not taken any action. That's why the petitioner approached your lordship, and they have filed an affidavit, my lord, not really denying anything. The only thing they say that fishery rules are not applicable so far as the Fishery Development Corporation is concerned. But your lordship is aware, my lord, there is a bench decision which says that, my lord, the spirit will be applicable. In any case, my lord, they also submitted on the previous occasion that they are considering it. They have to pass an order, my lord. That is the
What is the
limited.
full bench decision?
My lord,
What is the decision, dear? PD followed, we followed.
my lord, that is, my lord, Harrier Dablong case. My lord, may I submit a copy?
Because it will be difficult for us to enter into facts.
It may not be necessary, my lord. Your lordship may direct that you may
Consider-
consider as per the reports and take a decision.
Yes, Mr. Sharma.
Lordship, if that is so, I don't have any objection, but if Lordship goes to their tender part, then there is a tender clause that they cannot claim Lordship. They have signed it also by giving.
No, handing over position is
That
delayed.
that is agreed. If it is so, we are going to the records, department is always giving. Handing over
Because,
position, no issue, Lordship.
You cannot, that will be unjust
No,
enrichment.
Lordship, that
That will be unjust enrichment.
we always adjust, Lordship, that part. Regarding this part, Lordship, there is a clause that will suffice their grievances, Lordship. There is a clause, Lordship, may I read, Lordship? নির্বাচিত নিবিদা
Is it part of the record?
No, my lord.
Okay,
Lordship,
read louder.
নিৰ্বাচিত নিবিদাকাৰীয়ে বানপানী খৰাং মাছৰ বেমাৰ বলপূৰ্বকভাৱে অন্য লোকে মাছ ধৰা বিষক্ৰিয়া চুৰি হোৱা মীনমহলৰ বেদখল দখল চমজি নোপোৱা বা নতুবা অন্যান্য প্ৰাকৃতিক দুৰ্যোগৰ বাবে হ'ব পৰা লোকচানৰ বাবে নিগম দায়বদ্ধ নহ'ব আৰু এনে ঘটনা আদি দ্বাৰা নিৰ্বাচিত নিবিদাকাৰী লোকচান হ'লেও এনেবোৰ অজুহাতত মীনমহলৰ ৰাজহ ৰেহাই নাপাব। While submitting the tender bid, they have signed it. They have signed. Ratan Biswas signed it also. All bidder used to sign it. So Lordship, here is, I remember Lordship, one judgment is also there. It was not being interfered by the division bench. Where this clause is being said that as because this clause is there. So, court was reluctant to interfere in the matter there. Lordship, in this case, Lordship, as per my learned senior is saying that we may consider the representation that will suffice there.
Okay. As per its own merits and as per law
As per NIT.
and as per its own merits.
Lordship.
Yes, my lord, on the basis of the reports are there,
Oh,
same, my lord, they can.
In some cases, Lordship, if siltation is there, after we sometimes gives when siltation is there, when the fishery is not being able to do, in that case, we are giving, Lordship. If siltation report is there.
The report is already there, my lord. If your lordship may see the reports at page 61 and 63.
Let us have the facts. What is the settlement order?
My lord, the fishery was settled on, my lord, settlement order at page 26, 27, my. On 10th of October 2022, my lord, was settled.
At what price?
My lord, it was for a price of my annual bid of rupees 20 lakhs 94,000 and odd. For 7 years, it is 2 crores 18 lakhs and odd. Sir, I have written the synopsis also. The reports at page 61 and page 61, 61 by the circle officer, 63 by the district fishery development.
P1.
61 and 63, man. And that was pursuant to the direction of the, my lord, district commissioner to cause an inquiry.
One by circle officer.
This is
And
by,
next one.
next one is page 63, man. That is by the fishery development, district fishery development.
Petitioner. Who is the existing lessee, book settlement holder of a fishery named Samoguri fishery has approached this court by an instant petition under Article 226 of the Constitution of India, seeking inter alia raising inter alia a plea of waiver of revenue for a period of 216 days on the ground of delayed handing over of possession of the fishery. Full stop. A direction. The nature of mandamus has also been sought for a direction to the respondent authorities in the Assam Fisheries Development Corporation to take a decision as regards the petitioner's plea of reassessment of revenue of the fishery due to reduction in the fishing area due to natural calamities and other supervening circumstance. Para. The fishery named Samuguri Fishery is under the aegis of the AFDC Limited. So, by tender notice number 9/2020, bids were invited for settlement of the fishery located in this located in the district of Nagaon. Full stop. Pursuant to the bidding process so initiated, and upon evaluation of the bids, the petitioner emerged as the successful bidder. Full stop. Para by way of a settlement order stroke proposal dated 10/10/2022. The petitioner was offered settlement of the fishery from the financial year 2020 to 2023 for a period of 7 years up to 31/3/2023. Stop. In the settlement proposal, it was mentioned that the fishery would be settled for an amount of rupees 19,63,862.33 for a period for the financial year or up to 31/3/2029. Agor. For the financial year 2022, that's 2023, up to 31/3/2023, at rupees 19,67,862.33. and for an annual settlement amount of rupees 19 lakh, sorry, and for the remaining 6 years from the financial year 2028-2029 to 2028 to the financial year 2028-2029. That is up to 31/3/2029 for a total amount of rupees 1,98,60,000. Full stop. In other words, comma, the total, the petitioner was offered the settlement of the fishery for a total amount of rupees 2,18,27,862.30. Full stop. By offering the settlement proposal, the petitioner was asked to accept the same by depositing the installment amounts mentioned therein and by executing the contract agreement within a period of 7 days therefrom. Full stop. Para.
I have the final settlement order, Lordship. Again.
It is there, page 29. Responding to the settlement proposal dated 10/10/2022.
Yes, Lord. Sorry. I have overlooked it.
Comma, the petitioner deposited the requisite amounts as asked for, comma, and executed the contract agreement by completing the formalities. So which was thereafter, comma, the final settlement order was passed on 5/11/2022. So as per the final settlement order, the area of the fishery consisted of 60.00 hectares of land and 60.00 hectares of land area and water area. It was mentioned in the final settlement order that the possession of the fishery would be handed over as per the AFDCL's rules and regulations in order to enable the petitioner as the settlement holder to operate the fishery. It was on fourteen 11 2020. No, it was when it was handed over.
Handed over, my lord, fifth of November 2022.
According to the petitioner, comma, after the final settlement order dated 5/11/2020, the possession of the fishery was handed over to him on 5/11/2022. So, on and from 5/11/2020, comma, the petitioner started to operate the fishery. Para. As the fishery was handed over, as the possession of the fishery was handed over belatedly, comma, the petitioner on 14/11/2022 submitted an application before the respondent above to apprising the said fact with a request to waive the period from 1/4/2022 with a request to exempt the petitioner to deposit exempt the petitioner from depositing the proportionate amount of the settlement, proportion amount from the settlement amount for a period from 1/4/2022 to the date of handing over possession of the fishery. Full stop. After being handed over the possession of the fishery, comma, the petitioner came to learn that a large area of the fishery was covered by water hyacinth. And due to accumulation of water hyacinth, the water in the fishery was found stagnant. And due to reduced area for fishing, the petitioner started incurring losses as against the settlement amount he had offered by considering the area of the fishery mentioned in the tender notice. Full stop. Such reasons compelled the petitioner to submit representations before the respondent number 2 from time to time, requesting the respondent number 2 to take appropriate measures expediently so as to enable the petitioner to do fishing in the entire area of the fishery as projected in the tender note. Full stop. The petitioner has also brought to the notice of the respondent number 2 that there have been encroachment in the within the area of the fishery. So the though for a period of time, the respondent number 2 did not act on those representations. Stop. Subsequently, the respondent number 2 had directed had requested the district commissioner Nagaon on 9/7/2024 to take necessary action on the basis of the representation submitted by the petition. Para. On the basis of a direction and in reference to the office letter dated 9/7/2024 of the respondent number 2, the jurisdictional circle officer, that is the circle officer Samoguri Revenue Circle, made an inquiry and recording his findings, submitted a report before the District Commissioner Nagaon, respondent number 3, on 16/7/2024. Stop. The district fishery development officer Nagaon had also submitted a report to the circle officer Samoguri Revenue Circle. To respond to 6 in bracket. On 19/8/2024, highlighting the making an assessment as regards the damage caused to the fishery by flood. Full stop. As per the report of the respondent number 6, comma, the fishery was severely affected by flood. Recent flood, by recent flood. And there was significant ecological changes as a result. As a result, there were significant ecological changes. Causing habitat disruption, comma, increased sedimentation, etc. As per the report dated 16/7/2024 of the circle officer, comma, due to breakage, due to break in the embankment, due to breaking of the embankment by the flood water, a substantial area of the fishery was covered by water hyacinth. Resulting in as a subsequent representation of the petitioner submitted by the petitioner before the respondent number 2 on the basis of the said reports seeking waiver stroke remission of the fishery revenue, seeking waiver stroke remission and reassessment of the fishery revenue, did not bring succor. A petitioner is before this court by the present petition seeking the above reliefs. Mr. I have heard Mr. M.K. Choudhury, Senior Counsel Estate by Mr. Medhi Learned for the petitioner, Mr. P. Karma Learned Standing Counsel, Fishery Department and AFBC Limited. On not fishery, no. No. AFBC Limited for the respondent number 1, 2, 4, and Mr. Where is Bokolial? Mr. G. Bokolial Lanet. You are government broker also?
No, I'm not.
Okay.
Just
G. Bokolial Lanet. Call him. G. Bokolial Lanet. Government broker.
and for 4 I'm
4 you were there. 3,
1,
5,
2, 1, 2, 4.
3, 5,
6 fishery department.
6.
6 is also I'm.
Okay. Right. Standing Counsel, Fishery Department and ABC Limited. For the respondent number 1, 2, 4, and 6. And Mr. Z. Bokolia. Recommend both. Or 3, 5, and
3 and 7. 7 also.
Mr. Toril, as senior counsel for the pit, has submitted that despite repeated approaches and representation, as annexed to the pre-petition by the petitioner seeking waiver stroke remission and reassessment of the revenue of the Samoguri fishery. The respondent number 2 has not taken any discernible action for consideration of the representative. He has submitted that it is well within the authority and jurisdiction of the respondent number 2 to make waiver, to grant waiver, stroke remission, and reassessment of the revenue of the fishery by taking into account the relevant factors like reduction in the area of fishing, encroachment of the encroachment made into the fishery area and etc. As the matters as the aspects highlighted by the petitioner, the representative are within the domain of the respondent number 2, the respondent number 2 ought to have given consideration to such representation. So, Mr. Sharma and extension has submitted that there is the entry of clause 12,
20.5.
25 in the tender notice, the petitioner could not have sought for such benefits as highlighted. The in so far as the contention regarding delayed handing over possession of the fishery is concerned, this court is of the considered view that if the if after the order of settlement, there was delay in handing over concern, it is the an amount if an amount was offered for operating the for a whole year, for a whole financial year, for operating the fishery, and by a bidder, by the successful bidder, by the there was operating the fishery. And if for any reason beyond his control, like delayed handing over of position of the fishery by the settlement authority, then the settlement holder can take proportionate fixation of the fixation of the revenue for such reduced period for which he was able to operate the fishery. So, insofar as the other factors highlighted by the petition, comma, it is for the response number 2, as the settlement authority to take such factors into consideration. So as the representative of the petition are yet to be given consideration, comma, this is of the highlighting the factors which the petitioner is seeking waivers of remission and reassessment of the revenue of the fishery. The response number 2 ought to have given consideration to the representation, more particularly, comma, when there are reports on such aspects from 2 authorities. That is the respondent number 7. So, in such view of the matter, comma, without commenting on the respective claims of the parties, comma, this court consider view that it can be disposed of with a direction to take the representation already submitted by Dr. on board, and after consideration of the representation and the reports submitted by the respondent number 6 and the respondent 7, comma, the disposal of the representation on its own merits in accordance with law by passing a order to stop. The respondent shall also consider the fixation of the settlement amount due to delayed handing over possession of the fishery. You need a partial hearing. That will be helpful. The respondent number 2, before while considering the representation, shall also afford a personal hearing to the petitioner. So, it is the speaking order shall be passed as expeditiously as possible, comma, but in an outer limit of 6 weeks. 6 weeks from the date of submission of a certificate copy by the petitioner before the respondent with the above observation and direction given above. Repeat.
Highly obliged. Highly obliged.
I have not read the brief, whatever it is there, so I'll make the correction after this.
It is there.
Same NIT.
Same NIT, Lordship, same,
Huh?
same NIT. Representation has been
No,
lost.
Kali.
Earlier order is.
Yes, Miss Neo.
My lords. As per my verbal instruction, authority is already going to withdraw this process.
It is likely otherwise it is very arbitrary.
Yes,
Yeah.
yes.
Primarily it's very arbitrary.
Yes, Your Honor.
It is the executive engineer does a finishing act,
Yes,
nobody would be able to submit bid.
yes, Your
Their contractors are prudent businessmen. They know what to do in the bid. They on their own visit the site, see what are the difficulties.
Yes, Your Honor.
They prepare their bids.
The symmetry.
They know. They are class 1B, 1A businessmen. They know. The Supreme Court has already held that they are prudent businessmen. They structure their bid according to the situation. Okay. Where is NIT?
That is Lordship, page number
Okay.
14.
On top. On top.
Seven is 15. Lord.
Which one is the bid? Okay. 7 works?
7 works, Lordship.
7 works, right?
Yes.
Petitioners. Oh. Can do submit. You submit request.
Lordship, 84, 85, 86.
Date.
That 11/2/2026.
11/2/2026.
Lordship.
Then one representation.
One representation, Lordship. Then Lordship chief is also
Tell
sitting here.
me. I am not looking at the file.
Lordship. One representation to the executive engineer, Lordship.
Date.
11/2/2026. Same date, Lordship.
All together or separate?
Separate.
Huh?
Separate.
Petitioners. Dated that sub. Individual representation.
Individual evidence.
Eleven two.
11/2.
Today is gone, only tomorrow is left.
Tomorrow is. I think 26,
So 25,
25,
25, you tomorrow visit,
Lordship.
right, madam?
Yes, sir. It is
Tomorrow.
20, it is, last date is 27 to 26.
Last date is 27.
Yes, sir.
So after visit, they have to get the certificate. Thereafter, they have to upload the bid. If the whole day 27,
Already 3 order has been passed.
okay,
26 evening, I have to upload it.
you have to upload.
Lordship. Otherwise,
So tomorrow and day after tomorrow,
Yes,
Lordship.
sir.
right?
Plus.
Okay, with site visit 25, 26,
Lordship.
and certificate 26,
Lordship.
right? On or before 26,
Lordship.
PSB listed 27.
Lordship.
27, last date is 27.
27.
If certificate is granted, we will close the petition,
Lordship.
right?
Yes.
Or otherwise, we may have to proceed further,
Lordship.
allowing you to submit your bid without,
Without certificate.
okay.
Deeply
Apply.
obliged.
Please, Your Lordship.
Hmm.
Lordship, this petition pertains to.
Just a minute, madam, just a minute.
Lordship.
Yes, Mr. Gogoi, if the synopsis is correct.
Well, my lord, of course, my lord, in the writ petition, my lord, that work completion certificate as well as my lord, completion of the DLP, defect liability period completion is also there. But my lord, these are my lord central fund schemes. In the affidavit that we have filed, my lord, we have, my lord, explained, my lord, that, my lord, it is the central government who finally decides whether, my lord, the maintenance period was duly maintained during the maintenance period, my lord, whether the petitioner has performed or not, the contractor has performed or not. Even after giving that certificate, it is they decide. Now, in the present case, my lord, after it was issued and it was uploaded in the portal, the defect liability period has been further extended till 23/3/2027. Also, you will find that in the affidavit at page 53. And my lord, this particular document is not under challenge. 53, my lord, 5525.
Annexure 1,
Annexure A, yes, A,
A,
A, my lord.
15.5.
15/5/2025, yes. Lords, you will find in the next page, my lord, the unsatisfactory performance of the package is for a period of 28 months. To ensure, thus the package is extended for 28 months, that is up to 23/3/2027. Performance security deposit is to be released by finance only when its performance in DLP is satisfactory either in the extended period as original period.
Who is the person who has issued?
PIU inserts.
It bears no signature.
My lord, these are all system generated, E-mark, my lord. So you will see, my lord, in the first phase, in the left-hand side down below, my lord, E-mark.
And who is this PIU in charge? Is from which authority?
My lord, here, my lord, this says the Department of PWD Assam.
If it is no.
Now, what is that, my lord, module? That has been explained at page 55. There is a communication of the central government.
Just it. Annexure B.
Annexure B, my lord.
Yes, what do you say? Something is generated by them,
Lordship, this,
annex are A,
yes, your lordship. Lordship,
as per the standard bid agreement.
uh, they have introduced a new mechanism for your lordship to monitor the maintenance of road. And this mechanism was brought on 2025, your lord.
Hmm?
And your lordship, I
34.
38th of April, 2025, your lordship.
Where from you are saying?
Lordship, annexure B, the affidavit that they have filed, page
Annex
55.
B.
Page 55, your lost, Lordship, may I read, Lordship, as you are aware that the provision in PMGSY standard B document clause 32.1 states that the engineer shall give notice to the contractor of any defect before the end of the defect liability period, which begins from the completion date and ends after 5 years. The defect liability period shall be extended as long as defects be corrected, your lordship.
Now, whether this authority is party? This authority is a party.
No, your lord.
So that
Lordship,
is one problem.
Lordship, why I'm saying, this SOP will not be applicable to, why? Because I had completed the work on 18/1/20.
That I have understood.
Yes, your
That I have understood your
Yes,
case.
yes, your lord.
This has been introduced on 30,
Yes, your,
but the amount has been blocked from their end.
yes, your lord.
And they have extended,
Yes, your
as
lord.
per this period,
Yes, your-
28 months have been extended by them. Why don't you file an bidding application? Because it is a necessary party. Then only we can direct that authority to release, because you have introduced a system which was after expiry of 5 years defect liability period.
Yeah, and
So this cannot be made retrospectively.
Yes,
Right? Cannot be given effect to.
yes.
Now, their purse is empty. Purse is with this particular person, right? Even if you thereafter file a contempt, that will not be a contempt. Because despite their bona fide, they will come up with a defense that we are not
We're not.
in a position because they are not. And secondly, this authority is not a party. It is up to you. Now they are holding the purse. Money they are holding. Your money. It is in their kitty, not under their control.
Since this SOP will not be applicable,
That I have understood, but is nothing can be done behind someone's back. Now they have come up with that.
because this is
This is an instruction. This is a decision. Though the department is there, but this PIU is acting under the instruction of that agency. To my limited understanding, National Rural Infrastructure Development
Development
Agency. They are holding the purse, right? Mr. Gogoi?
Yes, madam.
They are giving the money.
PIU is the program implementation unit. So they have.
So they are acting under their instruction.
otherwise, the tender was issued by the chief.
Right. To that extent, I have understood your case.
Not. It was issued by the chief. And nowhere in the document, this mechanism has been stated here. And besides your lordship, a notice has to be given, that not given.
Other than this document, or the stand taken in the affidavit, where is there any mention somewhere about this agency?
Yes, para 6, Lordship will see, my lord, page
The affidavit.
47. Yes.
Other than that, the contract agreement,
Oh, your lordship.
NIT, bidding document,
Two mechanisms. Have introduced
in maintain competition private. Private. Whatever. Delete. Click. Okay. The completion certificate was issued when?
also it was issued on 24/4/20.
4/2000.
Page 37 is the defect liability certificate. Page 38 is defect liability. Pursuance of clause 8. Agreement.
But come to page 56. This was in 20th July. It is not that the system is in place. The system is in place on July 20, 2023. E-mark was there already.
Yes.
There you-
Hmm.
After this, SOP and my lordship.
No,
and-
SOP was already there. Read page 56.
I have
Yes, routine inspection clause 2. 38, page 56, clause 2. As per SBT clause 38.2. Then 3. The defect liability period shall be extended for as long as the defect remains to be corrected. Page 57. First,
all corrected, and that is why certificates were issued. And lordship, if I may place with document your
now chief engineer is saying, ultimately these are, executive engineer has issued all the certificate I have seen. But it is the chief engineer
oh yeah.
who has to Who has the final say? Your documents.
So as per the contract act, conditions of the contract, defect liability certificate is
Where is the contract?
not.
Page 28, Lordship will see the letter of acceptance. Put by the chief engineer.
No, all these are issued by civil engineer. Certificates I have seen are issued by executive engineer.
Lordship,
Right.
may peruse the definition, just placed a bit. From last, your Lordship, third, the defects liability ID here, after the defects liability period has ended and
Which clause you are reading?
definition, your Lordship. The first bit. General condition contract. Defect liability.
Yes.
The certificate by the engineer. And the engineer is the person named in the contract data or any other competent.
Yes. Come to page 28. Who employs the contractor? Come to page 28. Read the first line.
By you.
Employer is chief engineer, not executive engineer. This is a notice to proceed for the work. Right. Then come to page 29. Agreement.
Chief engineer.
Chief engineer. Hereinafter call the employer. Right. Then to 31. ITB clause 30. Payment is clause 39. Employer. So ultimately it boils down to employer.
Here, even here, the is the person in the contract data or any other competent person appointed by the employer and notified to placement team is responsible.
So if you want to see. If you read clause 38, then 39. $39.1.
Contract.
The employer shall pay the contractor the amounts the engineer has certified within 15 days of the date of each certificate. So employer is chief engineer, engineer is maybe executive engineer. And what is your case in the affidavit in reply?
Also, 5 years. Right. Because Your
No,
Lordship,
those are, I have understood those.
I have also annexed, one document. Failure. Now,
See there, paragraph 7. Affidavit in opposition. See paragraph 7. It is not that you have performed very well. There was non-performance for one full year from 24/3/2023 to 23/11/2024. 1 year, full year. You received 0 payment bill due to non-maintenance. And ultimately it is PMGSY. Meaning thereby it is central. In all the letters. In all the letters. It is PMGSY. The package itself is PMGSY. Agreement number, stroke so and so. Ultimately, unless you bring that, then the monitoring agency and funding agency is ultimately that agency. They are implementing agency, but monitoring and financing part is there, and there is non-performance. It is not the case that there is performance during a DLP. You can resume your prayer after implement. That option is available. Otherwise, you have to make them party. Because it is a funding agency and it is PMGSY. Ultimately, unquestionably, it is central fund. It comes from central government. They are implementing agency.
In fact, page 40 will clarify the same. There is a letter of the executive engineer who has issued that mallet completion certificate. He has now requested the empowered officer ASRB and chief engineer PWD border roads to release the mallet. So main authority will be this authority. And this is a nodal agency for implementation of the PMGSY scheme, as well as the fund part, accounting part.
And I have seen this one, another one, better. Whoever is certifying, say last page, miss last page.
Yes.
This is the thing by empowered officer. That statement.
Yes, sir.
PMGSY maintenance fund. So, chief engineer acts as empowered officer ASRB. Then see copy to the officer in charge PIU. Aju Swalkosi Territorial Road Division. So, there is officer in charge PIU. Now, this notice, impugn one, or the difficult one, it was difficult for you. This was by PIU in charge. And it is not that, let us see that period. Now, is it your case that no notice was served on you? That is why I asked you, what is the case set up in the affidavit in reply? You went around something else.
We have not.
That is the problem. Had you set up that, yes, no notice, because this document they have relied upon, right? The scheme. It says that first para 55, clause 32.1 states that the engineer shall give notice to the contractor of any defect before the end of defect liability period. Right? That notice I asked you, what is the case set up by you in the affidavit in reply? But you went around repeating the same thing.
So that
is the problem. And writ petition is decided on pleadings, not on oral submission. Criminal case, oral submission can be done. But civil case and writ petition go by the pleading. That is not there. Had you have asserted that no notice under 32.1, so cannot be extended. Defect liability period cannot be extended. Where is 32.1? Here. Have you understood? It is for you to assert. Then
Notices were given. I can produce those. Let them reply. I will produce this. I will counter to my counter reply.
I can give you time
And
to assert that no notice was given, so defect liability period cannot be extended. Then Mr. Gogoi be obligated to produce those notices. By the time that 28 periods will be over, you can try. I don't, it is up to you. Have you pleaded that no notice was given in the affidavit in reply? So it is up to you. I can grant you liberty to file additional affidavit. Otherwise, exchange of pleading is complete. You have to seek leave.
Because here, in I,
But SOP is in,
that is
at
why,
least 2023, it is in. And there is specific assertion, there was non-performance for an entire period. So zero payment. Even for defect liability period, one gets payment.
Yes.
And there was zero payment.
until I
If
had,
you go on arguing on the same aspects, I have understood. I can dispose it of right now. Question is disputed questions of fact. It is very easy for the court in contractual matter to dispose of, relegating it to the civil court. Right? Because once concluded contract dispute are to be either by decided by the civil court or by arbitration, if provision for arbitration is there. But I tried to, if I agreed things are there, I can decide. But if it is not there, I'll relegate you to the arbitration or civil court. Simple as that. It is not that court is hearing. Court is hearing to settle the issues, if possible, without there being dispute. If dispute, small dispute, otherwise law is settled, concluded contract, parties are not governed by any fundamental right. It is only contractual right. And contractual right cannot be decided in a public law remedy under 226. Right? Arbitration or civil court. The more you argue, you will be in more difficulty. If you are really sure that no notice, then only.
that is what I had.
Take your instructions, you put it on Friday. If you find that no notice, then you seek leave. Have you understood?
Yes, sir.
Right, Mr. Gogoi?
Madam.
Since money has been retained, so that is why I am giving you this opportunity. Miss
Are you?
B. Mushahar, Learning Counsel for the petition, and Mr. B. Goyal, Learning Standing Counsel, Additional Advocate in Assam for the state response. Ms. Musahari has sought for a sort of accommodation to complete her instructions as sought for. Is the case on Monday? Monday. Second bore ho jao niki. Okay, just for this instruction. If you think, if your client says that I was served with no notice, then you seek leave. Otherwise, you will close, you have to wait till expiry of 28 months. Just a minute. Trade union.
Trade union.
What is trade union? What is the meaning of trade union?
Isn't that sick?
Hmm?
Is given in the page of the act.
Means any Congress. Yes.
Presented 21/12/2020. Worship find the application.
Thirty? 26.
Because application fulfill the mandate of the section 5 and 6 of the Trade Union Act. And the members of the trade union.
By the number of applicants, yes, it fulfills.
They are
And what do you say about workmen?
workmen.
Who is workman?
This member are those who are working as a mahut.
Because definition, it has to be trade union. And also there is trade dispute. Right? It is, I don't know, somewhat akin to yes, had it been a society, it would have been a completely different scenario. Now, trade union. Yes, by the number, how many? What is the application? Mode of registration?
Yes.
Any 7 or more members. So far as that is concerned, you fulfill. Right?
Right.
I'll not go to the next part. Right. Schedule, you have office bearers, you have prescribed. That these will be our office bearers. Then, but general members, okay. You have said that 80, 95, 107 members, right? Now let us see the speaking order.
Page 30.
Mr. Roy, you are representing?
The only respondent.
Registrar.
Register of trade union.
Okay. I am going slow because I am also unfamiliar.
Lordship,
Mr. Mazumdar,
Lordship.
anywhere in the Act, workman has been defined,
No, in the Trade Union Act, the definition of workman is not there. Is
not
defined,
defined, not defined.
defined in the industrial.
That I know. Is there any provision after the definition clause, anything, anything which is not defined in this Act is to be taken from the other Act?
There is,
let us come in. Is there any regulation? Nine small a. Why 9 small a? In the speaking order,
It's a capital A.
I should be capital A.
Capital.
Okay. It's all the. Mr. Mazumdar,
Lordship.
come to subsection 4 of section 11.
The event of dismissal of an appeal by any court appointed under the clause B, subsection 1, person aggrieved shall have the right shall have a right to appeal to the High Court. And the High Court shall, for the purpose of appeal, have been called the appeal. Part in appeal, it was also dismissed.
Huh?
Part-
Then another matter.
They have
There is
filed,
another forum in Delhi.
no, Lordship,
Where is the appeal?
Is there subsequent?
Page number? Page number, Lordship, 50, 52 of my petition.
Huh?
That is the order, impugned order,
50?
52.
That is by labor code.
Labor
Labor-
code come to.
Then thereafter,
Thereafter, I am here, Lord.
how can it be? 11-4.
In the event of the dismissal of an appeal by any court appointed under clause B of subsection 1, the person agreed.
Person, 1 minute. Clause B of subsection 1. Let us read subsection. Any person aggrieved by any refusal of the registrar to register a trade union or by the withdrawal of cancellation of a certificate of registration within such period as may be prescribed appeal. B. Where the head office is situated in any area to such court not inferior to the court of an additional or assistant session judge of a civil court as the appropriate government may appoint. Now, where did you file the appeal?
The labor code, Gauhati.
Labor Code Gauhati. Lohit Kumar Soikia. Labor Code Gauhati. 11AA. This is a bit preferred by some. I've heard that a bit. And now come to page 55. Just 3 lines above. Just 3 lines above paragraph 6. On being agreed by the same, the appellant petitioner filed a writ petition before the Honorable High Court. Hence, the petition. What is the meaning?
Appellate court, there is labor court. I had directly approached the High Court, then High Court granted me the liberty. So, and you approach first the labor court, then come back again.
Have you stated in the petition?
Yes.
Okay. By order, so and so granted liberty to prefer an appeal. Okay, prefer an appeal. So you prefer the appeal. And that is the order. This is- Now let us read page 56 in a region.
The point number 2, whether the order passed to the Register of Trade Unions, 2nd October 2022 is legal or void. It is the contention of the appellant that on 21st 12/2021, the application was submitted to the Registrar of Trade Union Assam for registration under the name file Assam Hatifandi Union as per resolution adopted in a general meeting of the organization held on 11/10/2021. The application was submitted for registration along with the particulars document as required by the section 5(1) of the Trade Union Act 1926. After receiving the application, the Labor Commissioner asked the Superintendent of Police to furnish verification report of the members of the Executive Committee. Accordingly, Superintendent of Police, Nagaon, Morigao, Karjanglong, and Hutai District submitted verification report confirming nothing found adverse against the member. Learned counsel for the appellant has laid stress on section 9A of the Trade Union Act, relates the minimum membership requirement for a registration of the trade union. It mandates that the registered trade union of the workmen must at all times have not less than section 10 of, less than 10% of 100 of the workmen, whichever is less, subject to a minimum of 7 engaged or employed in the establishment or industry with which it is connected. On perusal of materials available on record, found that as per the report submitted by the labor officer Morigao, it was revealed that except members of the appellant organized trade union, that is namely Moniram Kalita, Numal Borua, and Bakhalia Gaur, at present working as Mahut in Taj, Kaziranga and Dabaka, all other 104 members are enlisted as the members of trade union, had been working in the different fields since the year of 1980. Further perusal of the case record shows that the appellant has annexed the identity of the members of the union in form of the certificate issued by the Gaupura in spite of section 5 of the Act of the.
Why he has observed so? Gaura cannot give certificate that these persons are Mao. Which is the elephant conjunction?
This my case is on the next paragraph. Entire case I said. Further perusal of the case record shows that the appellant has annexed the identities of the members of the union in form of the certificate issued by the Gaupura in spite of the section 5 of the Act, Elephant Preservation Act 1879. The power of issuing certificate for those professions are entrusted upon the district collector or the deputy commissioner of the district.
That is what I am asking. Where is the elephant?
No, section 5 is for killing and catching the elephant, not as a mahut. I have a copy of the Act, Lordship. I am not my profession is mahut. I am not going to kill the elephant. I am the rider of the elephant. It is citing the wrong provision of law. Elephant Preservation Act 1879. It's only two pages. Section 5 is in the second page.
industry specific. Something going on very strangely perhaps.
Perhaps, Lordship, one more submit.
Sir, no one. I'll express my view so that you can make, because till you are registered as a trade union, you are merely an association of persons. You are merely an association of persons. You have no juristic entity. Right? Just a minute. Now, come to this is an interesting one. So, come to section 11 again.
I read the entire section.
No, one by one, I am putting it across to you. Subsection 1, there is A, then AA and B. Now, subsection 1, two part. Any person agreed by refusal of the registrar to register a trade union. This is 1.
Yes.
So, refuse means you are association of persons. You are not a legal or juristic entity. Have you understood?
Yes.
Right. Second part, by the withdrawal or cancellation of a registration. Right. Second part, you are registered trade union. But by the act of withdrawal or by the act of cancellation, you are aggrieved. Now A, B, C. C. A, where the head office of the trade union is situated. This is not applicable to you. Right?
Because I have.
1 minute.
Yes.
You are not a trade union.
Yes, that is true.
Right. Please bear with that. Don't make
Lordship.
irrelevant submission. B, A and A. A, where the head office is situated in an area falling within the jurisdiction of a labor court or an industrial court to that court or tribunal. This can be invoked by a trade union. Now C. B. Where the head office is situated in any area, to such court not inferior to the court of an additional or assistant judge of a principal civil court of original jurisdiction, as the appropriate government may appoint in this behalf for that area. So, if you are an association of person, you can approach the civil court, principal civil court of original jurisdiction, because you are not a trade union, because that is apparent from subsection 4. Now, see, in the event of dismissal of an appeal by any court appointed under clause B of subsection 1, right? A person aggrieved shall have a right to appeal to the High Court. Here it is not trade union.
Yes.
And the High Court shall for the purpose of such so and so. On the other hand, if it is dismissed by labor court or industrial court, it is writ petition or maybe 227. That is why subsection 4 specifically to clause B. So that assumption of jurisdiction by the labor court in your appeal, perhaps without jurisdiction. Mr. This is a point to be pondered.
Yes.
Right? Where is the High Court order directing?
It was.
Because you said writ petition,
Yeah,
WBC kan ulapsan, WBC likho. No, this is an interesting one. WBC 6013 order, last disposal order. 6013
6013 of 2002, 22.
And High Court cannot confer a jurisdiction to a court. If a jurisdiction is conferred by the statute, and High Court says, go to the labor court, that is wrong. No, let me find out.
I'm just want to highlight that Lordship has pointed out a very interesting side of this act, but being randomly applied by the labor court, whenever an application.
You are an association of person.
That is absolutely.
Your status is not defined as a workman. You are projecting yourself as an association of workmen.
Lordship, workman, I'm not on that because workman is
Because
not.
otherwise, how can a labor court or industrial court, because I am looking at the definition of labor court and industrial tribunal, they are meant under the Industrial Dispute Act. It cannot go beyond.
Yes, as per section 11 of the act, they are supposed to interfere only the industrial dispute. Also,
Industrial dispute.
yes,
Because
absolutely.
section 7 labor code says for adjudication of industrial dispute relating to any matter in the second schedule. Industrial tribunal says section perhaps 8.
120.
Tribunal.
Yes,
Adjudication of industrial disputes. This is 6013/2022.
210, 2022 order.
And it says industrial dispute only. So, by virtue of this EB, special jurisdiction has been vested in a labor court and industrial tribunal to decide a matter regarding withdrawal or cancellation of registration of a trade union. Because by issuance, it is deemed they consist of workmen. In paragraph page 3, text of the case, paragraph 2:4, you said petitioner was granted liberty to prefer an appeal under section 11. But it should be an appeal under perhaps 11B. Mister, have you done any research?
We have done research so far the act is concerned, my lord, because his case, first of all, the state of Assam is not.
Because if the labor code
Yes,
assumes jurisdiction
wrongly.
Then it is non-est.
Non-est.
It has to be set aside.
Right.
And the petitioner should be granted the liberty to approach proper court,
Yes.
which is a civil court, because they are still association of persons. They have not been regarded as an association of workmen. They claim to be workmen.
Yes, they claim to be.
But their status has not been recognized by anybody.
I will be allowed to submit on this issue. Since the definition of workman is not there, the workman, who is the workman, the law is silent. Yes, that is true.
I know. It is also that unless it is not mentioned, court cannot import the definition from another act.
Then workman, the simple understanding is.
Because, no, I am showing because of that 11.4, a person. A person. Oh, sorry. You have wrongly mentioned, sir.
031.
Let me see the order. You correct it. Give on. It simply says 11. Court says simply 11. It goes by Godrej, Sara, entertainability and maintainability. Maintainability is all right, court said, but entertainability doubtful. I'm giving you the appellate remedy. Everything has gone on a different tangent, perhaps. I don't know. This is my first. Yes.
think that was not pointed out, my lord. The last occasion that was not pointed out.
Raised labor court. Register
Ah.
side.
এখন Pandora's box is opened. Pandora's box is open. This Elephant Act has already been repealed in 1930. AI is saying. Let me find out whether AI is correct or not. Right. And if that is the ground given by the appellate court, we can set aside the order and also observe in view of this whether that court has a jurisdiction to entertain. If Elephant Act 1879 is already been repealed before independence by the British, then
8 of 1930.
1930, that is what I have found. Then this observation is completely wrong. We can set it aside. And at the same time, we can also frame the issue whether in view of section 11, you have the jurisdiction to it.
Yes.
Have you understood?
Yes, Lordship, but I have a little.
Let us ascertain
Lordship.
whether that act is in existence or not. This Elephant Preservation Act. You have not done the research. You are making me to do the research. And you are wasting the time of the court. No. What is, you have the repealing act.
Repeal.
Is it there?
I think
1930.
That,
Repealing Act of 1930. It will be.
let me find out.
What is?
See, everything is going haywire.
And this provision during hearing, it was raised by them. They also submitted the relevant text to the court.
No, this is the act itself. The repealing act is 1930.
it's noted there in that 1930 repealed. Section 3.
Repealing and amending act 8 of 1930. Gone. Gone. It is gone with the wind. As far back during British time. Interesting one. Go through it. I don't copy did you? Put it on Thursday. Right. Thursday.
Lordship.
If the labor court had acted on 5, it was completely wrong because that act was not in existence. We'll set it aside on that count. Right. Next question is whether that court has the jurisdiction
To entertain appeal.
to entertain an appeal in view of provisions of section 11. Let us put it to the, so that we will not make the observation. Let us put it to the court. If that court finds, then he can return the claim. He can return to file it for the proper court. Then your issue of limitation is also solved. Right? So make a research on section 11, A, AA, and B. Now I am giving you the material instead of you giving me the material. And give one to Mr. Roy also. So this is completely illegal. Reliance on a repeal act is completely illegal. So order is erroneous. And that was the main ground on which your appeal was rejected. And we would have I started hearing you, I would have wasted more time.
Is it lordship?
Is it not? You will go on facts.
Section 11.
Sir, repealed.
No, I am just. reading section 11.
FZ Majumdar, petitioner. And J. Roy, senior counsel, State by Mr. As sought for by the supporter party, release the case on Thursday, day after tomorrow.
Lordship at 2 p.m.
We don't know the business of the court. If I am sure it will be a case of, if but transferred today, then it is a case of 5 minutes.
No, then it may be time is part hand, lordship.
I am sitting, Thursday, I am sitting, I am sure.
This week at least roster is not changing.
Huh?
This week roster is not changing.
So find out,
Lordship.
Mr. Roy.